Okay, it is noon, so we are going to get going so that we finish on time and on budget. Welcome to the Gowling WLG Annual Fall Construction Law Forum. My name is Ted Betts. I am a partner in the Gowling Toronto office and the head of our Infrastructure and Construction Law Group. We have been hosting these forums for over a decade now in order to share insights and updates on construction laws and practices to the industry. We are changing the format a little this fall, and the fall forum is only online. Our spring construction law forum will be in person in multiple offices across the country. We have another excellent program today focusing on current trends and practices in dispute resolution. Before we get going, I would like to make a land acknowledgement. As I am in the city of Toronto, I will acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewas, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13, signed by the Mississaugas of the Credit, and the Williams Treaties, signed by multiple Mississaugas and Chippewa bands. As always, we endeavor to deliver our program on time and on budget. And so with that, I will pass the microphone over to my partner, Mark Crane. Thank you for joining us.
Very good. So good afternoon, everyone. And as Ted said, thank you for attending. I want to wish you a warm welcome for attending this forum. My name's Mark Crane, and I'm a partner in the Toronto office of Gowling's, where I practice in the area of commercial litigation. And the focus of my practice is in large infrastructure disputes, amongst other disputes. And I also lead our firm's national arbitration practice group. And I'm going to slip down to our agenda. And for the next 20 minutes or so, I'm going to be delivering a presentation along with my accomplished partner, Sahil Shur, who's also up on the screen, and who also focuses in the area of construction and infrastructure disputes. And so the intention of our session here, which we've put up an agenda for the entire hour that we've got with you today, but the intention of our session is to discuss some of the growing or emerging trends within the arbitration space, and in particular within the infrastructure space, with a view to making ongoing improvements to the goal of an efficient, fair, timely, but balanced process. And reflecting for a moment, at a time where the courts, at least in this jurisdiction, are facing ongoing challenges to the administration of justice quickly, it was as recently reported by Sean Fine from the Globe and Mail back in September. I think there are increasing opportunities and perhaps increasing needs for arbitration to play an important role in dispute resolution. And so, I mean, having said that, I want to make it clear that I think there are examples where the courts are doing terrific work in this space. And Justice Conan from the Superior Court of Justice has dealt with disputes of enormous size arising out of projects like the Eglinton LRT and Steeles West and Finch West. So there's good things that the courts are doing in this space, but I think they themselves would concede that they don't have the bandwidth nor necessarily enough subject area expertise to do it all. And so arbitration continues to be a preferred dispute resolution choice amongst parties within the infrastructure space. I've put up one slide here that gives you some context. This is from a PwC survey. It's dated, and it's from an international arbitration perspective. But I think it is a helpful touch point to reflect on what the industry currently thinks of arbitration. So I think it continues to be a preferred choice in this space, and I expect that trend to continue. But in order to do so, I think it's healthy to have periodic reflection to identify where changes or evolution can occur, or at least be considered. It's healthy for this to take place, and so that's the theme for today's session. The second slide I've put up gives you some context for why parties are turning to arbitration. This is from an FTI Canadian survey from 2024, so relatively current information. It's a tricky slide to unpack, but I think if you'll see construction infrastructure being the third item listed is one of the leading industries that points parties towards arbitration, the other being contractual interpretation, which in and of itself may also capture the infrastructure space. And so with that wind up, I think I'll turn it over to Sahil and then back to me in a few minutes, where we're going to talk about utilizing AI powered tools in arbitration, what we can do about red fern requests, whether it makes sense to have questioning in arbitration, and a brief comment about Scott's schedules. So with that, Sahil, I'll pass it over to you.
No, thanks, Mark. Good afternoon, everybody. Like Mark mentioned, I'm Sahil Shur, partner here at Gowling's, and I have the utmost pleasure to speak with you about artificial intelligence and how, based on our experience to date, it is being incorporated in the projects early on. What is the thought process that is going behind developing robust dispute resolution provisions? How artificial intelligence and various models are being used in the practice of law, in the practice of arbitration, in running efficient, effective arbitration hearings. So Mark, if we could go to the next slide, please. And one of the main themes that I wanted to start with is, how do you navigate the integration of artificial intelligence into your projects? And what are some of the complexities behind which you should turn your mind to at the time of the drafting of the contract, as to how you are going to integrate, vet, and use artificial intelligence in your contracts? And one of the things that we are seeing, at least at the contract stage phase, are the parties having open communication among themselves, in particular, how AI is going to be used, how the data that is going to be developed, prepared using the AI tools and the models is going to be used within the context of the management of the project. And among other things, I want to give you a few themes that are becoming quite openly discussed at the contract phase, that includes site safety. And what I mean by site safety is, how is AI powered cameras and sensors can be used to monitor construction site, and whether that could be, the monitoring could be simply for the purposes of potential safety hazards before they happen, and how they can be used to alert workers and managers to potential dangers. What about another theme that we come across is predictive maintenance? And how can AI be used to analyze the data from the building systems, such as HVAC and electrical systems, to predict when maintenance will be needed and help prevent equipment failure? During the construction phase, we also find that the contracts are now considering how AI can be used to optimize scheduling, allocation of resources like equipment, and cost estimation, in order to make the projects more efficient and cost effective. There are some other themes pertaining to quality control and AI. From my understanding and in our experience, we're also seeing, working with the bid teams, AI being used both in takeoff and in estimation to come up with a price. And the way it is being used there is, the AI is being used to perform linear and takeoff measurements, as well as counting objects on architectural drawings. And the AI is then being used to calculate material quantities and labor cost. So with that background in mind, Mark, if we go to the next slide, please. With that background in mind, AI journey requires input from all stakeholders. And what I mean by that is whether or not AI is the appropriate vehicle for your project. What type of AI model is it that you're going to use? And what are some of the opportunities that may be available to you? And what are also some of the challenges and the risk that you ought to keep in mind when you are considering the application of artificial intelligence on your project? And one of the things you also need to keep in mind is the LLMs. And what I mean by the LLMs is because on large scale infrastructure projects, you are going to, if you're going to implement AI, the models are going to be largely, if not solely, going to be dependent on large language models. And the large language models, they do not tell you the answer to your question. But over time, what makes a difference or does not make a difference is depending on what type of question is being asked and what data is being inputted into the LLMs in order for you to get the answer. Next slide, please, Mark. So taking a step back, I mentioned that it requires an input from all stakeholders. And also the government standards that you ought to keep into mind in terms of whether or not you as an organization has the bandwidth and the internal resources to proceed with AI, or whether you need suppliers to supply the artificial intelligence that you ought to apply to your project. Some of the other items that you have to consider early on in the process, and this is, this becomes crucial piece during a disagreement between a party under the contract, or even during the claims management at the contract level, as to if you're going to collect the data, how is the data going to be collected? How is the data going to be stored? And the implementation of the AI, what are you going to do with the disclosure of AI in your contracts? Not just the parent contract, but also subsequent other contracts that you may enter into with contractors, subcontractors, and suppliers. So it requires various different viewpoints from, I just give 3 examples, businesses, tech, legal, but there could be various other stakeholders who will have an input as to how, if AI is adopted to apply on a project, how is it going to be executed? What are you going to be able to do with the work product? How is the work product going to be able to use down the road? And various other challenges and risks, and how do you best account for that? So moving away from requiring input from all of the stakeholders to some of the potential benefits that you can and we are seeing with the application of AI on the models that we are working with. So Mark, if we can go on the next slide, please. I give very high-level example of 4 themes, one being data, one being document analysis, leveraging algorithms and predictive analysis, and cost reduction and optimizing resources. In terms of, we all know that we create a lot of data, and there's a lot of documents that are created on construction projects, and Mark is going to speak about that. And one of the items that I want to focus on in particular is the predictive analysis. And what I mean by that is whether or not the AI model in the arbitration space, whether or not the predictive analysis tool give the parties an assistance with their due diligence in nominating arbitrators. So the tools which we have piloted can analyze arbitrator past cases to an extent, including rulings on specific issues if they are available, and that's a big question mark. The duration of the arbitral proceedings and the arbitral questions during oral hearings. This could also help parties identify and prevent potential conflicts of interest. And like I mentioned early on, these tools are dependent upon the use of machine learning logarithms and predictive analytics. It helps in the collection of the data, and potentially can also advise you on the outcome of the case. So with that backdrop, backdrop in mind, Mark, if we go to the next slide, please. And here I speak to you about some of the potential risk. You know, AI improves by learning, and without making mistakes, it cannot learn. And you know, we all have to agree to that. So at the contract formation stage, you also have to keep in mind in terms of the liability of the AI errors. Like if you are using an outside tool or an agency, like does AI have an agency? When will error trigger liability? Who will be liable? All of those things. And you know, the courts have started considering these issues. I came across these two cases, both out of BC, which involved Air Canada and chatbot liability, and another case which is again a chat GPT case out of British Columbia, where the court uses the term quote unquote AI hallucinations. And in that particular case, the court says that the risk of using ChatGPT and other similar tools for legal purposes was recently quantified in the 2024 study, and found the legal hallucinations are alarmingly prevalent, occurring between 69% of the time with ChatGPT 3.5 version and 88% with Llama 2. So some of the things that you also we are considering routinely are the practice directions from the courts. In the jurisdiction that Mark and I practice in, have a practice direction pertaining to the use of AI, both by counsel, parties involved, and including judges, and the limitation that they place on them. And including most arbitration institutions have advisories in terms of the use of AI and the limitations that they place on them. Speaking about the potential risk, Mark, if we could go to the next slide, please. One of the other areas that we find is the issue of maintaining privilege and confidentiality. And what I mean by privilege is that meetings with the clients, with the experts, witnesses are often being conducted using video conferencing platforms where AI note-taking applications attend these meetings to transcribe meeting notes and generate meeting summaries. So we as practitioners need to take precautions to ensure that the privilege is maintained over these AI-generated meeting notes and summaries, as some platforms are not secure, and you know, the tribunals, including the post-arbitration tribunals and the courts, may not deem that transcripts has been covered by a solicitor-client or litigation privilege, and they could order the disclosure of these documents. Another thing that you have to keep in mind is the lack of transparency. And what I mean by that is these large language models must be fed with high volume of data, which is representative of the data that the model will encounter once it is deployed in order to ensure accuracy. Because arbitration is typically a private and a confidential dispute, the available data is much more limited than it would be in litigation. Therefore, the larger the volume of data creates what is known as black box AI issue. It is unclear, at least to me, as to what the AI system can be used and analyzed in generating the predictions or analysis. So when you're working with an arbitration tribunal, it is very important to ensure transparency in the arbitration process, not only between the counsels and the parties, but also the tribunal members, i.e. the arbitrator, either one or a panel of arbitrators. You know, I am part of a discussion right now on an arbitration where there's a robust discussion pertaining to the use of Gen AI in the proceedings, and the tribunal is well aware of the use of the model and what limitations the parties are placing on each other. And lastly, I'll speak about bias before moving on to the next point. And what I mean by bias is that AI is not free from bias. If there is bias in the input, there is going to be bias in the output. So it is very important to keep in mind when relying on Gen AI content that AI system can replicate the biases of the data they have been trained on. So that is a very important component to keep in mind. And there's a whole robust different regulatory compliance issues in terms of regulations in the seat of the arbitration, the jurisdiction, the substantive law, enforcement. And these are all the topics and areas which need to be taken into account in terms of overcoming the challenges and some of the risks. So what does this mean in terms of next step? So Mark, if we could go to the next slide, please. So I question, so in that, what is next? Are we going to have AI-powered arbitrators? Are we going to have AI simply doing the arbitration? And so be it. So, but I stop and reflect that given the advances and the efficiencies of Gen AI, it is possible that some disputes may be appropriate for AI arbitrator. And in fact, eBay and PayPal, in my research for this presentation, I came across that eBay and PayPal is already resolving majority of their disputes through a logarithm-driven online dispute resolution platform. However, I am of the view that the large-scale infrastructure disputes, complex disputes involving design delay, they are not ready yet to be arbitrated by AI-empowered arbitrator. Because, and in my view, and this is simply my view, that even if an arbitrator modeled by an AI was going to be deciding on your dispute, that AI-powered arbitrator would likely lack emotional intelligence. They would lack context, judgment skills, and the ability to reconcile errors and the inconsistency, and the skills which are required to ensure due process and fairness. And while there are examples such as the New York Convention and the ICSID Convention, which do not expressly state that the arbitrators must be natural persons, many arbitrations laws and jurisdictions, including institutional rules, requires arbitrator to be natural person and or possess human qualities. At least that's what it says right now. So I'll stop there, Mark, and over to you.
Thanks, Sahil. That was very interesting. I have to say that my portion here won't be quite as provocative or thought-thinking as Sahil's was about the AI arbitrators that we may face maybe in our lifetime at some stage, but very interesting to think about. I agree with Sahil that they may not be ready yet for the construction infrastructure space. Just interesting on that point. I was listening to someone speak about AI, and they talked about whether AI could possess the quality of empathy. Anyway, that's something that we can all think about. As I mentioned in my introduction a few minutes ago, I'm going to touch on Redfern's requests, questioning, and Scott's schedules very briefly in the time that I've got. I've put this slide up because I thought it was interesting. It doesn't have anything specifically to do with Redfern requests, but I thought it would be helpful. It's timely, and it's Canadian based as to some of the reasons where a dispute resolution clause isn't embedded into, sorry, when an arbitration clause isn't embedded into the dispute resolution clause of the commercial agreement, the reasons why. And on domestic arbitration, you can see that costs of the arbitration was the fourth or the fifth likeliest column, and costs was a driving factor in 15% of the respondents for international arbitration. I don't think any of that touches squarely within Redfern's, but I thought it was an interesting metric to look at. I'm going to spend a few minutes talking about Redfern requests, and just for the benefit of everyone on the call, and in case some people don't know what is a Redfern request schedule? And this slide provides some context for what it is and what it looks like, which many of you already know. But what's difference, in a traditional litigation in the courts, parties subject to a dispute and arbitration in the courts are generally required to produce an affidavit of documents, which requires parties to produce the documents that are relevant to the proceedings. Relevance being defined by what's been pled in the pleadings, so the statement of claim, the statement of defenses, that is in their power, possession, and control. It can be quite overwhelming for a corporation to be required to swear an affidavit to state that it's produced all documents in its power, possession, and control. And so in arbitration cases, with a view to reducing the time and expense, and I think time and expense is amongst the qualities that I think the arbitration community markets itself to distinguish itself from the courts, with a view to being more efficient. We often come across Redfern requests, and that's where the party opposite will make specific requests of the party of the documents that they think they will require in order to defend and or prosecute their respective claims. And I think it can be quite an effective tool. But as you'll hear me say in a few minutes, I think there are some modifications that we can consider with a view, particularly in infrastructure disputes, with a view to assisting the mandates getting on more quickly. So I think in some cases, what we found is, or what I find actually, I suppose, but I think it's fairly common, is that the Redfern process can be quite time consuming, overwhelming, and at the end of the day, not much different than an affidavit of documents in terms of the time and expense. Different in the output, but maybe not much different in the time and expense. And when you think about litigation, whether it's in the courts or arbitration, I think there are various humps where the legal spend spikes. One time may be around the time of the pleadings. A second time most certainly will be around the document production, and so on, depending on the steps as you move forward. But document production is always going to be a big lift in terms of time and expense. And so I think there are ways where the arbitration community can try and distinguish itself and refine what it's doing. Maybe turning that garden hose a quarter inch to the right, not up, turning it upside down, but where can we modify it? And so, but first off, maybe it makes sense to think about why this is happening. And I think, from my own perspective, I think lawyers sometimes feel like the Redfern request at the outset of the process is their only opportunity to be making requests of documents. And so they don't want to leave anything behind of risk of perhaps being accused of missing something that they should have asked for. And so it tends to, notwithstanding sometimes the best of intentions, where parties will say, let's be streamlined and let's be focused on just the documents we need, I think oftentimes it devolves into an all-encompassing exercise. And then I think, given the obligation in a Redfern request to generally code documents associated with a specific request, that can be quite a time-intensive process, and we often underestimate the time and resources necessary to do that, to fully comply with a Redfern request. And so when you compare that to an affidavit of documents, you begin to wonder whether it may not be just more efficient just to produce the project file minus privileged documents, and get on with it, at least from your production responsibility perspective. So I think that's some of the reasons as to the why the Redfern requests. I think separately but related, I think as we look through the Redfern request process, we have to be mindful that there is an imbalance about information as between the parties. And I think that matters, that's to state the obvious, but I think it matters particularly in infrastructure disputes because generally speaking, in infrastructure disputes, experts, where there are technical claims that have been pled, whether they're standard of care matters or entitlement or schedule or delay, experts are going to have a lot to say in the outcome of these disputes, whether the matters actually get to the arbitration or whether they get off-ramped at some point in advance of the arbitration at a mediation or some other stage. And so I think one of the issues is a Redfern process can take a long time to get the documents out the door for the reasons that I described last time, is they can be voluminous. And if there's a deadline to produce documents, experts may not be getting documents that they may require to carry out their mandates in a timely manner. And I think sometimes tactics can get involved in that, where there's an imbalance in key documents. And so I think there's a requirement, you know, as you would expect, that you want to make sure that parties get the documents they need to prosecute and to defend the litigation, but you know, having regard through a lens of proportionality. And as I've said, to the extent that the arbitration industry markets itself as being able to get things on more quickly than the courts, and I think that's part of its selling feature, then it's incumbent upon it to make sure that it can get through what I say is a big hurdle in litigation over documentary production relatively quickly. And so I don't think there's no quick fix to this. As Sahil mentioned in his portion, document production is you know, the volume of documents and communications that parties are exchanging during the course of projects is voluminous. It's gargantuan. That's not going to change. And so I think we have to be mindful of where we can make modifications that can get, you know, can assist the parties get on with their mandates, notwithstanding the enormous task. And so with that in mind, I've come up with a number of recommendations, and none of these are going to should be earth-shattering, but I think if implemented and if you know, agreed to by parties, can make a meaningful difference in terms of time and to get the matter ready for arbitration or mediation, whatever it is you're trying to accomplish as quickly and as efficiently as possible. And the first point, as I raise, as you see on the screen, is a prioritization of productions. I mentioned that experts will have a lot to say in the outcome of these disputes. They often do, where there are technical claims and claims of entitlement or schedule or delay. And so Redfern requests tend to be overwhelming sometimes in size. I think we should prioritize them. Prioritize the ones that you need to get answered quickly so that your experts can get on with their respective mandates. Even if they're preparing responding reports, there's still a lot of work that can get done in the background while they were waiting for the affirmative reports to be delivered. And so it's a tiered Redfern response process that I would invite. I think it should be with input from experts, and we're going to have a panel of experts that are going to be talking about this and other issues. But I think that will allow experts, particularly a delay expert who waiting on construction schedules. There's no reason, in my view, that parties to a dispute where delay has been asserted, that there shouldn't be an exchange of construction schedules and related documents, you know, at the first opportunity. And doing this, I think, will eliminate or reduce some of the tactics that can go on in document production, and ultimately driving what I think may be a more efficient and timely process. Two, I think I would consider case conferences frequently. Sounds pithy, but I think particularly during the time of the exchange of the key documents, you want to have frequent touch points, because it keeps parties their respective feet to their fire to get things done. Again, why? So that you can get documents in the hands of experts. Why? So that they can carry out their mandates, which will be likely no resolution, be it before an arbitrator or otherwise. It's going to happen until those events have occurred. And in that respect, you know, some of the expert mandates will be on the critical path in terms of the litigation. And so having frequent touch points, I think, keeps people motivated and you know, compelled to produce what may be easy lifting documents to produce in any event. On this point, I think you want to be mindful of the selection of the arbitrator. Not all of them will have time to have frequent case management. And so as you're going through the process, you may wish to consider someone who's going to have scope to have touch points with counsel every month or so as you go through this process. 3, anchoring correspondence, I think, with specific dates and to specific custodians with specific date ranges, I think will help to get on with the process of documentary productions. And I raise here, be prepared to produce stuff that's irrelevant. If it's project related and it's irrelevant to a particular claim, shouldn't much care. And I think that would just help expedite things. And lastly and finally on this point, I'd say that concede that, if we can concede that a Redfern request process is a living tree and not one and done, at the front end of the litigation, then that may relieve some of the burden and stress that counsel and parties feel to ask for everything they might want to need at some point in stage during the file. And I think a Redfern request should be a living tree because things will emerge over the course of the file that may wish you to revisit some of the requests or add to the requests. 2 final points, and then I'm going to push off to our panel. Oral discovery and questioning it, depending on which part of the country you're at, is sort of an interesting topic in arbitration. As many of you know, oral discovery tends not to be a boilerplate component of a discovery process. And we saw from the survey of counsel the slide that I had up on the monitor a few minutes ago, that some have identified the lack of discovery as to why they may not wish to include an arbitration clause in the commercial agreement. And so one thought, and I have, and I think, notwithstanding that every case is different, will turn on its own facts, and that should dictate process, including procedure. If you have oral discovery only with leave, with a view that leave's only granted if you're trying to understand a document that's been produced. And I say this why? Because to the extent experts or counsel have a question about the true understanding, so a true discovery about what that document means or what's intended to mean, if doing so would entitle the parties to get on with their mandates, including their expert mandates, more quickly, I think that would be helpful. But I think having it granted only with leave puts some guardrails up so that it's not going to be abused or extended beyond the scope I've just described. Scott schedules, the final point here, and I think they're important to use in an infrastructure dispute where the claims are voluminous. Some of these matters will have claims that exceed 100, and you can get lost and confused, just lost in the organization of it all. But to draw one analogy, if you don't use one, but to draw an analogy, I was recently speaking with an expert who commented to me that he estimated that his fees would have been $2 million less had the parties used a Scott schedule, not a file that I was involved with. But just given the people being unclear about what they were responding to or what the arbitrator wanted queries about, gave rise to a lack of organization and clarity. And so I thought that was a helpful antidote in the spirit of trying to be more efficient and timely in these dispute resolution processes. So that's what I had to share with you all. Thank you very much. And I'm going to pass it off to Natasha and the panel.
Thanks, Mark. Could you stop sharing your screen? Thank you. Good afternoon, everybody. My name is Natasha Carew. I'm a partner in Gowling WLG's advocacy group. Apologies for my raspy voice today. I'm grateful to our panelists who are joining me. I have Rebecca Longpre, who is claims counsel at Bird Construction, Lorna Tardif, who is a quantum and delay expert at HKA, and Mira Wagman, who is a delay and disruption expert at Secretariat. We will be discussing the trend in construction and infrastructure disputes towards the collaborative use of expert witnesses. This includes the preparation of joint expert reports and the practice of hot tubbing or witness conferencing between opposing experts. If we have time, we'll also briefly touch on the appointment of an arbitrator's own expert. A joint expert report is collaboratively prepared by experts who are retained by opposing parties in a dispute. Through this process, experts may align on key aspects such as methodology, for example, selecting an appropriate method of delay analysis, and on underlying facts or assumptions, such as identifying the correct baseline schedule. The aim of a joint report is to clarify areas of agreement and disagreement between the experts with the goal of narrowing the issues in dispute. And when successful, joint reports can significantly streamline court or arbitration proceedings and focus an adjudication only on the truly contentious issues. To start, I'd like to invite our expert panelists to share their experience with preparing joint reports. So Lorna, could you begin by telling us about your experience with these reports, and specifically if you've found that they contribute meaningfully to resolving disputes?
Well, thank you, Natasha. It's a pleasure to be here. My experience with joint expert reports begins with how you define the purpose of them. And what we see is an expectation among the parties that a joint report will somehow narrow the gap between the conclusions of the two opposing experts. What we as experts are faced with is three fundamental factors that drive our analysis and conclusions and that are completely beyond our control. And the first, of course, is the facts. And you might think that, well, the facts are the facts, there shouldn't really be any issue there, but I'm sure anyone that's ever been involved with litigation knows that that is certainly not always the case. And as experts, that's not our job. The second is opinions from subject matter experts. When we're doing a delay analysis or quantifying damages, we're often required to rely on opinions on technical matters, be they ground conditions or performance factors or other matters that require expertise from a specialized expert. Again, as a delay analyst, I'm asked to rely upon these various expert reports, and it's not upon me to change them or to compromise in any way. And then the third, of course, many of the issues that we address in delay analysis requires legal interpretation. Again, outside of the scope of the independent expert, what we do is we take instruction from counsel. So certainly we can collaborate and produce a joint report, and certainly we can address where we differ and why we differ. But my experience has been that we have not been able to narrow the gap simply because it's not our role to address these factors that are outside of our control. So I'll stop there.
All right, I see. So you're saying that the council really needs to get involved to enable this process to proceed effectively.
Well, by identifying the differences and the reasons for them, there's certainly value to that. If counsel and if the arbitrators want to know what the opinion would be if certain parameters changed, that's certainly something that we as experts can do, but we need to be instructed to do it.
Mm-hmm. Mira, how about you? What's your experience been with preparing joint reports?
Sure. I'm going to start because I think it's the shorter answer with kind of the negative experience, and then I'll talk a little bit about I've had some very successful joint expert report processes. Negatives are really when the two experts are just so far apart, and or one of the experts, not me, but the opposing expert is not collaborative or cooperative. It's just a waste of time. It's really ineffective. It's really inefficient. I think all it does is generate more fees, which goes to the high cost of arbitration. So I have been involved in processes where it has really not yielded any benefit. Luckily, I have actually more often than not been involved in positive joint expert processes. So, and to follow on what Lorna is saying, in my experience, it's a little different. I've had experience is one where the tribunal has instructed specific topics to address. More commonly, the experts themselves kind of independently from scratch start with, okay, where do we have some areas of agreement that we can kind of synthesize for the tribunal? And then we move into where are we disagreeing and why? And talk where we have areas of agreement, it really creates this heat map, I call it, or a cheat sheet for the tribunal to lessen their work, right? If they can do less thinking, I think they can think about, as you said, the more important factors. So for instance, if we're two delay experts, we may have a period of time where we agree on what the critical path is, and we actually even agree or can come to agreement if we adjust our time periods to how many days of delay were incurred on that critical path. And then it really is all that's left for the tribunal is that entitlement decision, basically looking at the technical issues or the legal and contractual. And so it kind of distills it down to what does the tribunal really need to focus on in order to come to their decision, and kind of get rid of some of the noise that I'll admittedly say delay reports come with, because they have to be very complex and detailed. Recently, I was involved in one where, interestingly, the first joint expert report was instructed prior to any issuance of either expert's actual reports. So it was you start the process, have a joint expert meeting, try to agree on basics like the baseline, key as-built dates, certain documents that need to be incorporated into the analysis. And then interestingly, the hardest one to come to agreement is methodology. And that's the biggest kind of kicker of why we have these differences usually. And so couldn't agree. And the tribunal actually instructed us to apply both methodologies. So both experts had to apply both methodologies and see how that played out. And then over the course of developing the expert report and the reply report, we went through, it was, I guess, like Mark said, a living tree of the joint expert report concept. We had, I think, 6 or 7 iterations and updates to that report. And then it culminated with a final joint expert kind of table that was used by the tribunal in the hearing. And that was really successful because then we ended up in the hot tub or witness conferencing, and the tribunal asked very pointed questions about our table to help them get to their decision. It seemed like they were close to certain decisions and they needed a few clarifications. And that was probably the most successful process I had. So I think if it's well managed and you have experts that can collaborate effectively, it can work really well.
And do you think the fact that you were collaborating from such an early stage was part of the reason it was a successful process?
Absolutely.
You think it's better to collaborate at an early stage than a later stage?
I think absolutely, at least in that experience, because sometimes by the time you exchange reports and maybe things are being argued about, and you know the tenor or the collaborative nature is kind of spoiled after exchanging so many different reports and opinions and refuting the other expert. And then you have to say, okay, now sit down and talk about what you can potentially agree on after you've just written hundreds and hundreds of pages talking about why the other person is incorrect, right? It doesn't really help. The starting point of collaboration, I think, fostered the process to be more positive.
And one more follow-up, was that ordered by the tribunal in that case, or was that an agreement reached by council?
100% ordered by the tribunal.
Okay.
And I've seen more often, if it's not the experts deciding how the process goes, it is the tribunal. That's in my experience. Very rarely do we have any instruction by council.
Okay. And now I'd like to turn to Rebecca for your perspective as in-house claims counsel. Rebecca, do you see value in having experts from each party collaborate to align on key issues and narrow the scope of what is in dispute?
Yeah, in theory, I think it could be beneficial to have the expert agree on some key issues, like, building code violation are pretty technical. So if they don't agree to that, we're on for a pretty long dispute. And compliance with specification. But what I found in practice is that it's not always possible because the expert come for positions that are so far, so opposite. And often what I've seen is that at least one of the expert doesn't make any concession in their position or in their report, so it makes it very difficult to see any possible agreement on that level. And in my experience, the disputes that end up in arbitration are the ones where the parties already don't agree to anything. And so I see as being very difficult then to get our expert to agree to something.
Mm-hmm. And with respect to Mira's point about timing, have you seen any situations where you were able to bring in some collaboration between experts at an earlier stage, or perhaps even a pre-dispute stage when there's no formal dispute underway yet, and the parties are still working towards a very amicable settlement process?
I've seen it more at the pre-dispute early stage where really what the parties want to know is understand, let's say delay, understand what happened, who's responsible, for the goal to reach a resolution as opposed to just fight over it. So when there's no breakdown in the relationship between the parties, then I see collaboration working significantly better. And it doesn't turn into just a battle of the expert, but it's rather just understanding from a legal and expert perspective, like what happened on the project. So there's really open, frank discussion, trying to understand methodology used, and then you can reach resolution. But if the parties are not collaborating from the onset, then in my experience, it turns into battles of the expert that have complete opposite position. And if that's the case, then I would be more inclined to have the expert align at the end once they've exchanged their reports, once the position have crystallized, because then it's easier to find some flaws in the opinions and then to get parties to realize that they need to make some compromises. But
okay, I see. So either early on when the parties are still in a collaborative phase, pre-dispute phase perhaps, or wait until each party has a crystallized expert report and then put the experts together to try to narrow the issues from those reports. That makes sense. Let's get into the logistics a little bit. So Mira, do your joint expert meetings typically take place with council present or without their involvement? And do you have a preference?
So I will say typically, meaning in my experience, I've never had council present in the joint meetings. So all of my joint expert processes were just the experts. And well, not knowing the other side of it, but I guess that's my preference, because I do think it's kind of a without prejudice, safe space. You can kind of talk openly, and you can get down into the kind of weeds of what it is you're talking about, and I think it creates a more comfortable environment, hopefully, for the experts to really start sharing and engaging with each other. And again, my colleagues in my firm and I was chatting with them last night. None of us have ever had counsel actually on in our meetings or on our calls. Really back to the experts as independent experts to drive the process.
I see. And Lorna, how about you? Do you prefer counsel or no counsel involvement, or have they been present in your meetings that you've had?
Same as Mira. My experience has been that the meetings have taken place without council present. However, I can say that council were very interested in what the discussion was going to be, and there were some very frank and direct discussions about what assumptions council was prepared to compromise on. And now I'm talking about assumptions that fall in the category of those that are outside of the control of the expert, where we can, with the opposing experts, say, listen, if your position that you have taken or your counsel has taken on whatever is correct, then we can see that this flows through and results in a reduction or increase in the amount of delay and damages, etc. And there are situations where council has been prepared for me as an expert to enter into that discussion, and others where they were categorically not. So although council is not present, they certainly control the parameters under which it goes beyond discussion, where I can go in the discussion with the opposing expert.
Like with respect to certain concessions, perhaps, that might be made. Like, would they allow you to, without prejudice, in the informal way, because it must be difficult as an expert to have this sort of meeting and be strictly controlled as to what you can and can't say when the whole intent of the meeting is to be collaborative and reach common ground. So presumably it must be some sort of, like framework where you're permitted, you know, on a without prejudice basis to explore options without making any formal concession.
Well, Natasha, our role as experts is not to negotiate. That's not our job. We're there to address a technical issue that the arbitrator requires expertise on. So when you use the word concession, I mean, as an expert, if I've made a mistake, I face up to it. That's straightforward. But these other matters, that was a strange
Oh, it's an
buzzing in the
Amber
background.
Alert. Amber Alert. Yeah.
All right. So you're using the word concession. I would use it more a change in my instructions. You know, we accept that the findings of a subject matter expert need to be modified from A to B. How does that change my analysis? Fine, I'll do that. No problem. And discuss with the opposing expert how that flows through an analysis and what the results are. But I'm not the one, it's not me that's making the concession, and it's not me that's negotiating. I'm just doing my job as an independent expert.
Got it. And Rebecca,
Collaboratively, but I'm doing it.
yeah, as counsel, Rebecca, would you feel comfortable allowing your expert to meet with the opposing party's expert without you being present?
To some degree, like if parties are actually collaborating, then I wouldn't be as hesitant to agree to that. Obviously, like not making decisions without consulting us, but my issue is more when the parties aren't in that position, because it doesn't really matter at the end of the day what the expert say or not, because the parties make the decision. So what I've seen is some parties just taking this very strong position and they're not willing to budge on anything. And so if we give them a little bit, they'll take way more. It just makes negotiation more difficult because they only see the flaws on your position, but not the ones on theirs. So dealing with those parties, I would have a harder time agreeing to that, because I don't see how it would result to a mutually agreeable settlement, as opposed to them just finding ways to strengthen their position only.
Mm-hmm. Thank you. All right, so we are very close to the end. We are going to touch briefly on the idea of an arbitrator appointing their own expert under Section 28 of the Arbitration Act, where the expert participates in the hearing and the parties are given an opportunity to question them, but they are there, you know, they are essentially appointed for the benefit specifically of the arbitrator. I suppose we can each, do you want to, Lorna and Mira, I know you both have had experience with this. Do you want to give me your 30-second thoughts on this and whether it's been valuable to the resolution of the disputes that you were involved in? And then we will have to wrap it up so we can finish on time.
30 seconds. Yes, very valuable, provided that the role of the expert appointed by the arbitrator is well defined, and that expert does not simply become a third expert with special consideration.
Right.
Yep, I totally agree. I think if the expert is just there to help the tribunal understand the opposing analyses and the deep issues with the methodologies and kind of be advising in the background, I think it can work very well. And I would say not becoming a third expert, but really becoming a fourth arbitrator is where we've seen some issues where the tribunal kind of just deferred to this other expert to be really a decision maker, and I don't think that's appropriate.
Right. Okay. All right. Well, thank you to Rebecca, Mira, and Lorna. We really appreciate your time joining us today and your insights. And I'll pass it back to Ted.
Thank you.
Great, thank you. And thank you to all of our panelists and moderators. A special thank you to our guest panelists, Rebecca, Mira, and Lorna. That was fantastic. A lot of great information to digest. And also to the Gowling team behind the team, Margaret Williams and Jennifer Estrada, who made this digitally happen. Gowling is one of the largest and most comprehensive construction and infrastructure practices in the country and indeed the world, as we are an international global firm. We specialize in large infrastructure and construction projects, whether that is a P3 project, power plants, master plan development, communities, real estate development, mines, whatever it is, any large and complicated construction we can handle. We have a large and experienced team on both the front end contracting and structuring, as well as the back end dispute resolution. We also provide a unique project counsel service that many find very useful and helpful to assist clients to manage and navigate your projects after the contracts are signed, and the procurement team hands the project over to the project implementation team. From training on the contract to document and notice management and early dispute settlement or notice communications with contractors and owners. Thank you all for joining. We will be sharing a recording of this forum and our slides on our website. We will send out a notice when that's available. We want our forums to be as responsive to your needs and interests, so we will be circulating a short survey after to all attendees, and I encourage you to take the 60 seconds it will take to complete it so that we continue to provide exactly what you need to hear. Finally, please ensure you are signed up for our distribution list so you can receive building brief letters on current issues and construction law and notices of future events. Thank you and have a great remainder of 2024.